Yes, Mr. Hartley.
My lords, my ladies, just before the lunchtime break, we had looked at Clunis and the judgment of Justice Belden. I'm going to skip time past Gray in relation to Clunis because that's essentially distilled in Henderson to make the points which I wish to make, and you have our written submissions on it. But the case of Henderson is clearly very important in this claim. I appreciate how familiar this court is with that case, but just to remind that the claimant sought to distinguish her claim from Mr. Gray's and Mr. Clunis's on the basis of remarks made by the sentencing judge that she bore no significant personal responsibility for her criminal offence. And in the alternative, Mrs. Henderson urged the court to depart from Gray and overrule Clunis on the basis that they were inconsistent with Patel and Mirza. And this court rejected both of those arguments. I want to dwell on the response to her application, her efforts to distinguish her case from Gray and Clunis. She sought, in effect, to minimise the distinction between her offence and an insanity case, and to resist a bright-line distinction between diminished responsibility manslaughter cases and insanity cases, a distinction which had been drawn in Clunis and referred to with no criticism in Gray. And she submitted that the civil courts should adopt a different approach to the question of responsibility than the criminal courts adopted in the McNaughton rules. The arguments made by the claimant are summarised by Lord Hamblin in his judgment between paragraphs 98 to 104, which for your note are at page 1742 and 1743 of the bundle. And he describes them as formidable, but insufficient to justify departure from Gray. I'm going to ask you to focus on the judgment of Lord Hamblin in rejecting those submissions in a moment, but the points which we submit can be taken from this part of the judgment are that Lord Hamblin endorses and emphasises the distinction drawn in Clunis between diminished responsibility manslaughter and insanity cases. He explains the rationale for that is consistency, and he explicitly emphasises by explicit reference to the McNaughton rules in a way that was more implicitly done in Clunis, that departure by the civil courts from those rules would increase inconsistency between the civil and the criminal courts. So I invite you to go to the relevant paragraphs, which are page 1743 of the bundle, paragraphs 105 to 108. As explained above, the key consideration as far as the majority in Gray were concerned was that the claimant had been found to be criminally responsible for his acts, that he had been convicted of manslaughter on grounds of diminished responsibility meant that responsibility for his acts was diminished, but it was not removed. It was not an insanity case, and so, as Lord Justice Belden pointed out in Clunis, he must be taken to have known what he was doing and that it was wrong. In such circumstances, the majority in Gray justifiably considered that inconsistency would arise, not only if he was allowed to recover damages resulting from the sentence, but also if they resulted from the intentional criminal act for which he had been held responsible. To allow recovery would be to attribute responsibility for that criminal act, not as determined by the, would be to attribute responsibility for that criminal act, not as determined by the criminal law to the criminal, but to someone else, namely the tortious defendant. There is a contradiction between the law's treatment of conduct as criminal and acceptance that such conduct could give rise to a civil right of reimbursement. The criminal, under the criminal law, becomes the victim under the tort law. Whilst the wider rule may not involve, as the application of the narrower rule does, the law giving with one hand what it takes away with the other, it does involve, as Lord Hughes said in Hunger and Allen, the law condoning when facing right what it condemns when facing left. And it's paragraph 108 that he deals with the M'Naughton rules specifically. If, as the appellant submits, the degree of personal responsibility is a matter for the trial judge to determine in the civil claim, there's a clear risk of inconsistent decisions being reached in the criminal and the civil courts, both as to the degree of responsibility involved and as to how that is to be determined. If, as is further submitted, it is appropriate for the civil court to move away from the M'Naughton approach to insanity and to develop its own approach to such issues, then the inconsistencies will be heightened. Paragraph 109, I won't read because I read it to you earlier, but it's in relation to the fact that there was no penal element in the sentence which was imposed on Mrs. Henderson, and that didn't alter things. The conviction itself was the punishment. In short, the distinction drawn in Lord Beldham's judgment in Clunis between diminished responsibility, manslaughter and insanity has been endorsed and emphasised and explained in Henderson. And the implications of this would, of course, not have been lost on your lordships, who had heard argument about that distinction, about the appropriateness of a bright line, and who'd considered, for example, the case of Hunter and Presland, where a person who was insane, its claim was rejected, albeit we say not on grounds straightforwardly of the illegality defence. And our submission is that Lord Justice Underhill's judgment, where he says that the implication, or it should follow from this central reasoning, that the defence would not apply in an insanity case, it is arrived at carefully, but is also one which was the view of Mr. Justice Johnson in Traylor, of Mr. Justice Garnham in this case, as well, of course, of the President in this case. They had all understood that to be the implication of the reasoning. And it's true to say that Lady Justice Andrews, in the minority judgment in the court below, makes the point that the fact a serious crime had been committed in Henderson was sufficient to dispose of the appeal. It's her view that Lord Hamblin was treating the claimant's knowledge of wrongdoing as an additional, not an essential factor, which is, I think, the point Lady Simler was making earlier. And perhaps I made the point already. It's right that the fact of the conviction would have been enough. There was no need to underline that or add to that with the culpability distinction with insanity. But in my submission, it's relevant and important to note that the Supreme Court chose to do so. The Court chose to do so. It is not only the fact of the manslaughter that's relied on, but repeatedly the absence of culpability, that he didn't know, she did know what she was doing was wrong. And this was a central point, I think, in the minority judgment, in the majority judgment of the President in the court below, the fact that this is a principled distinction. She set out, as I've referred to before, the criminal law's distinction and the scrupulous exercise undertaken to determine whether somebody is guilty or of diminished responsibility, manslaughter, or not guilty by reason of insanity. And she says in the bundle at page 312, if you want to turn to her judgment, paragraph 157, that it is against this background that application of the doctrine of ex terpai causa to this civil claim needs to be considered. And she then sets out the same key passages referred to in Henderson and Gray from Clunis. And she concludes, and it's in the bundle at page 313, at paragraph 161. Each of these cases draws a coherent and bright-line distinction for the purposes of the ex turpi causa doctrine between those who are criminally responsible for their acts, whether fully or partially, and those who are not responsible for their acts because they do not know what they're doing is morally and legally wrong. And an important sentence. In my judgment, this common thread running through the criminal and the civil law is consistent with principle, a proper understanding of the true implications of acute mental illness, and is one that would not offend the sensibilities of ordinary right-thinking members of the public or undermine confidence in the law. From a different angle, the appellants in this case also seem to minimize the distinction. We invite you to reject that. They also seek to minimize the relevance of these decisions to this case. We invite you to reject that. They're clearly relevant cases. They contemplate each of those. Henderson, Gray, and Clunis contemplate a set of circumstances where a person has killed whilst insane and the application of the illegality defence to that. It's very central reasoning. And in our submission, heed should be paid to that. But it's also for the principled reasons. Yes, I've just, the authorities from the other jurisdictions, which I was going to go to, in fact have very detailed consideration of those by Lord Justice Underhill from page 281. Let me just check I've got these references right. Yeah. From page 281 of his judgment, pages 284 to 289, so for 5 pages, he considers the judgment, the Australian judgment of Hunter and Presland, and at 289 he considers Ellis. We've also dealt with these authorities in some detail in our written case on page 248. And then we've also dealt in our written case not only with Hunter, which is paragraphs 82 to 86, but with Barker, the additional case brought before this court, paragraphs 87 to 91. In the interest of moving on to consider the application of Patel to this case and the trio of considerations, and to give that sufficient time, after all, this aspect. My lords, my ladies, then we turn to the question of what happens if you apply the trio of consideration test in Patel to the events of the 10th of February. This is dealt with at section 8H of our written case, which is page 251 of the bundle. But in essence, and I won't repeat everything there because there's detailed submissions on policies under A, B, and C, and so on, but in essence, it is the claimant's case that the courts below were right to find that if the illegality defence is engaged, application of these 3 considerations arrives at the same result and the claim should be allowed to proceed. It matters in my submission, before you embark on the exercise of applying the 3 considerations, that you identify with some care the prohibition which has been transgressed, because that affects the answers. What policies underlie a transgression of or a prohibition in criminal law, it's not the same answer as to what policies, public policies, underlie the tort law and a transgression of that. And so in considering the consistency principle, which I'll come to first, I do separate whether we're looking at crime or tort. The consistency principle, of course, is the weightiest of all of the considerations. And we say there is no crime, and you can't, it doesn't make sense to consider whether there's an inconsistency as a consequence of crime, because there was none. But there are arguments, of course, made by the appellants that there would be inconsistency between the civil and the criminal law if the claim was permitted, in relation to, and I think this is the primary argument, and I think the only inconsistency argument that the first defendant adopts with criminal law, is the hospital order. It is argued that criminal law caused this damage and that it would be inconsistent to compensate for it. This same fact that a Section 3741 order could be made under the Criminal Procedure and Sanity Act is relied on in support of the argument that the claimant's behaviour engaged the interest of the state, public interest of the state. It said, well, the state's interested because it's the state's courts which make this order. And I think a point I've perhaps overly laboured, but just to make it again, that's not, in the context of the illegality defence, the relevant public interest. Whether the state has had an interest in a pragmatic solution to manage safety and treatment orders, the public interest with which this illegality defence is concerned is consistency and the linked public policy interest of preventing a claimant from profiting from that wrong. And for reasons explained earlier this morning, or considered earlier this morning, it is our submission that the Crown Court's power to make the hospital order comes partly through the Section 5 of the Criminal Procedure and Sanity Act, but the power that enables them to actually do it is the Section 37. It's the mental health law of this country, and it only arises where there is clinical evidence. But it matters perhaps not too much where that power precisely derives from. The nature of the order which is made is an order which is not punitive.
It is an order that deprives him of his liberty.
Yes.
And there was a question whether the court should, with one hand, be depriving a person of his liberty and with another hand compensating him for his being deprived of his liberty.
It doesn't deprive him of his liberty because he's done something wrong.
No.
Or criminal. It considers, with the benefit of medical evidence, whether it's safe for the public to let him leave court, as one did pre-1800. And if the medical evidence says, no, not now, then he goes from court to a hospital, not one named by the Secretary of State anymore, just he goes to a hospital for treatment where there is appropriate treatment available for him. That's a condition of it. And once he is there, it's very little different to how it would be if he were under a Section 3. There are some further restrictions in relation, for example, by the 41 that... yes.
Well, I've been in one of these hospitals. They're not quite the same as ordinary psychiatric hospitals. But the point is that his civil claim proceeds on the basis that this is damage. And the damage is caused by the court acting in accordance with an Act of Parliament. the question raised in relation to consistency is whether it is coherent for what X hypothesise for the purposes of a claim is damage to be inflicted by the court with one hand and compensation for that damage awarded by the court on the other hand.
If that follows through, there would be a distinction drawn between somebody who has a hospital order made and somebody who doesn't have a hospital order made because they're better by the time of trial.
Yes.
It's not a coherent...
Or they're not being deprived of their liberty. No. I mean, if we're assuming somebody who isn't being required to stay in a psychiatric hospital.
But if there is a claim in the ordinary way where the Court of Protection, for example, have made an order depriving somebody of their liberty through a dole's order, nobody says, well, that's inconsistent. And it wasn't, with respect, the reason that in Henderson and in Gray, when the same order was looked at, Section 3741, neither the House of Lords nor the Supreme Court reached to say, well, it's because it's got a punitive nature, or it's because it's the fact that it flows from a criminal conviction, and it is the stigma, the fact of that. The court would be condoning on one hand what it condemns on another, and here there's been no condemnation, so yes.
But here his complaint is that he was not detained after the arrest for grievous bodily harm. His complaint is he was negligently released. So I suppose this is, if the claim were to go ahead, one would then have to work out, suppose everything had gone as he says it ought to have gone, would he still be where he is now?
As a matter of quantification of damages.
Well, is it just a matter of quantification of damages? Or is it causation?
Arguably in relation to causation.
Yes.
In this case, the evidence...
If his claim is, I ought to have been detained on the night of the 9th of February. But he still maintains that his detention after the 10th of February, he's not claiming damages, or is he claiming damages for his detention as from his conviction or as from the commission of the murders?
He's claiming damages for his period of time and a detention which would not have occurred but for the negligence of the defendants. And the medical evidence in the case is that, and the way the schedule is pleaded, is that he would have been, had he been taken to hospital that night and treated, he would, as he had on previous occasions, have been responsive to medication, and he would have recovered sufficiently, and his risk profile would have been such that he would likely have been discharged within about 6 months of that time, probably on a community treatment order, because this would have been his third detention. And so that we say is matters which can all properly be looked at in looking at the claim in a civil court. They're not a reason to close the doors of the civil court on saying that he had a loss and saying what would otherwise be a good claim, that that loss was caused by the negligence of the defendants in allowing him to be out and amongst the public that night. Excuse me. Okay, thank you. Mr. Johnson reminds me that in the particulars of claim, page 508 of the bundle, we set out the causation claim in that way. I think, I hope that answers the question, Mary, but I think that I think I've made the point that it's not this which Henderson and Gray treated as the punishment or the condemnation or the losses. And in tortious actions, claimants frequently make losses for detention, which have been imposed by courts or are monitored by courts.
Is there a case in the Bible which is an illustration of that having happened?
No, it's fairly bread and butter in terms of in practice. So you might have somebody who's had a brain injury or who's had a psychotic relapse as a consequence of negligent treatment, that they would then claim as a part of their losses the fact that they had had a period where their liberty was restrained or taken away. And there are some additional points, I think, made by at least one of the defendants about consistency with the criminal law on grounds that the act should be treated as criminal or unlawful or actus reus mens rea, a sort of quasi-criminal. I think I've probably exhausted your patience on making those points this morning, but we rely on Felsted and the King and the 1964 Criminal Procedure Insanity Act and Crown and Antoine. So in summary, in relation to inconsistency with the criminal law, we say there is none, and there isn't any punishment that would qualify for that. Which takes us then to focus, I think, where the defendants' or the appellants' arguments really lies, which is whether permitting the claim would bring what's variously called incoherence or inconsistency between the civil law of illegality and the civil law of personal injury claims.
Is this then stage A of the trio of considerations?
I hope I'm looking at the consistency principle, which normally comes in, yes, to stage A. Thank you. Before we go on to look at that consistency, just to dwell with tort for a moment, and the reason why it's important to identify the nature of the prohibition transgressed that I touched on at the beginning, is that if the illegality defence is applied to this case, it will be an expansion of the illegality defence which has not happened before. To apply to a tort in circumstances where there was no culpability for that. And it's to apply a draconian defence. I don't want to overuse the word, but it's not a limiting defence on parts here and there. It's a draconian defence, closing the court's doors or common law court doors on that. And one has to ask, what is the purpose of that? Is it needed? Why wouldn't the court want to look in the round at all of the different losses that flowed from that disaster? In our submission, there isn't any deficiency in civil law which needs that. It's coherent for this court to hear the claimant's claim and also to hear claims against him.
Is it a deficiency in civil law which would justify the application of the defence, or the need to give effect to public policy, overriding the interests of the parties?
Yeah, your Lordship puts it better than me then. We say there isn't any. It doesn't defend against that consistency principle, because that is the normal stuff of tort, if I put it like that. So if a party is found liable for, if in this example, let's take this example, the fact that the claimant sues G4S and the police and so on, and the court can look at it and say what the losses were, he would then, as a part of that claim, he looks to recover a part of the losses, which might include an indemnity, an indemnity that's needed to cover losses claimed against him. That happens all of the time, that one in tort, there's a loss and you can look elsewhere to claim some assistance with that, whether that's going to your indemnity policy of insurance or whether that is going to somebody who's been at fault and put you in the position to cause this loss.
Usually it's done by contribution proceeding.
Or contribution.
But presumably you can't rely on that here because the appellants are not themselves liable to the victim.
That's certainly the argument, yes. And so there's another route, and it wouldn't have to be by an indemnity. You could assess the loss as it is as of today with loss of chance and so on, but it's a claim in that way. But the suggestion that it would create incoherence in tort law to permit what happens all of the time in tort law is, we say, wrong. One of the core functions of tort is to consider on the basis of all of the facts, all of the duties and the liabilities owed by two different parties, where responsibilities lie, whose those liabilities should be, where the losses fall. And it's well equipped to do that. It has, for example, contributory negligence. It has causation and remoteness arguments at its hands. And the alternative, what's being sought here, is that is put to one side, and instead all of the losses caused by the negligence of the state provision of custody and mental health services should fall at the door of a severely unwell man whom they knew was severely unwell, where they had been told that there was a grave danger if he was allowed to leave, and where they had seen that because when they'd allowed him to leave the day before, he had assaulted another elderly man. Why should, it's a simple point, why should all of the losses fall there if this court is able to, if the civil courts are able to adjudicate those losses without making the law act hypocritically? And in our submission it can. It can coherently and consistent with the treatment that he received in the criminal court permit this claim. And there's a further point before I leave this talk point, which is if one is to debar this claim on the grounds of incoherence within the civil law, you do so at the expense of inconsistency with the criminal law. In contrast to the criminal law, the civil law would be treating his conduct as immoral or illegal. There's no need, is my short submission, to extend the defence. There's no good public policy reason to do so. In fact, the obverse is true. I should say, I think a point I missed earlier, but it's perhaps so obvious, that there's nothing incoherent in civil law having one test as to whether you're responsible for the damage you caused to somebody, and a different test as to whether or not a particular defence can be applied to you. There's nothing unusual or odd about that. To have one test for his liability to the victims in this case, and another test for whether the illegality defence arises. I think a further inconsistency or incoherence that the appellants rely on is that they say that there is a risk if this claim is permitted to go ahead, well, two things. Firstly, there's a risk that defendants in criminal trials will make a sort of tactical decision to plead not guilty by reason of insanity where they would otherwise plead guilty to manslaughter. If the evidence in a case raises the question of whether a defendant is guilty or not guilty of the question of manslaughter, it's absolutely his right to defend himself on the basis that he's not guilty. And it's questionable whether a plea should be accepted otherwise to guilty of manslaughter. But that concern, I think, arises probably from before the changes in the law concerning disposal of people after their acquittal. Because the order made now is only where it's needed, and you're under the review of the Mental Health Tribunal and so on. And so there isn't the fear that there was back in the day of being detained indeterminately, throw away the key, whereas diminished responsibility might give you a better outcome. The same outcome is going to be determined because you're going to have the evidence of the clinicians as to that person's treatment needs at that time and their risk profile. And that will be kept constantly under review. The second point, I think, that the appellants raise as a risk of inconsistency, or another reason not to allow this, is that they say that there's a risk that there will be collateral attacks by claimants against their convictions or by defendants against their acquittals. And we have written submissions dealing with that from paragraph 117, which is at page 260 of the bundle. I might just add 2 points on this because I think it was raised yesterday, but about a collateral attack by a claimant against his conviction. And you'll remember that Mr. Moon has annexed a particulars of claim where that was alleged, although not, as I understood his submissions yesterday, followed through. Or we don't know what happened to the case, not adjudicated. In our submission, that would be highly likely to be struck out as an abusive process. It falls straight into the Hunter and Chief Police Constable of West Midlands reason for striking out on abuse. So far as the collateral attack by defendants against a claimant's acquittal, slightly more nuanced because I haven't seen examples of that. But in my submission, it's also highly unlikely to be acceptable to the courts. And we anticipate that that would be rejected and the matter struck out as an abuse. Mr. Warnock relied on the case of Gray and Barr to demonstrate that Lord Justice Denning had considered that, forgive me for a moment, I've forgotten if it was Mr. Barr or Mr. Gray, but that there had been a finding of, had been an acquittal, and not on grounds of insanity, but there had been an acquittal in that case, and Lord Justice Denning found that that was a generous acquittal, and he considered there had been manslaughter. But there was a central illegality, for example, in that case, there was a central issue in that case that even before the accidental shot, which killed the deceased, the defendant had taken his shotgun to the house and gone upstairs, shot it into the ceiling. So you've got an illegality in any event. But we think it's highly unlikely to be acceptable. We don't think Gray and Barr provides convincing evidence to the contrary. And in any event, if we're wrong about that, and defendants are entitled to challenge the acquittal of the claimant in cases such as this, and they choose not to exercise that restraint, but to try to go behind a jury's verdict, and if they are entitled to and allowed to do that, that would have to be dealt with by the trial judge. We anticipate that would be exceedingly rare. A jury finding would be, and the evidence that was then would be likely to be considered to be determinative. It may well be that the courts would quickly make a rule to say that defendants cannot challenge the not guilty by reason of insanity verdict. But in any event, this issue doesn't arise here, and it's not under consideration in this case that anybody's suggesting that. In conclusion, these factors regarding the consistency principle all go in favour of allowing the claim. Whether the illegality relied on is quasi-criminal category of having a hospital order or the tort of battery. The next weighty consideration is the public confidence principle. What is it? In my submission, its origin, as I think, I can't remember which my learned friends took you to yesterday, but the origin really comes from judgment in Gray, and it was considered in Henderson. And at paragraph, I'll take you to page 1733 of the bundle. And I've turned to this page because Lord Hamblin is distilling here the public policy considerations in Gray and interpreting them to some extent. So he's explained, you'll see when you look at the paragraph, that the consistency principle applies in relation to both the narrow and the wider claims. And he considers Lord Hoffman's justification for the wider rule being about the fair distribution of resources. And so that is at 58.3.
Paragraph? 58.
Paragraph 58.3,
yes.
page 1733.
Thank you.
Yes, so Lord Hoffman didn't consider that this consistency principle applied to the wide claim, but held that a related policy did, namely that it is offensive to public notions of the fair distribution of resources that a claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. And then Lord Hamblin says this: I understand this to mean that allowing a claimant to be compensated for the consequence of his own criminal conduct risks bringing the law into disrepute and diminishing respect for it. It is an outcome of which public opinion would be likely to disapprove and would thereby undermine the public confidence in the law, noting the criminal conduct in that. But he describes that as the public confidence principle. And he goes on to say at subparagraph 4, the public confidence principle is also applicable to the narrow claim. It's related to the consistency principle, since one of the reasons that the public would be likely to disapprove of the outcome is the inconsistency which it involves between the criminal law and the civil law. And to pay attention to the fact that in looking at the public confidence principle, Lord Hamblin has referred explicitly to the criminal conduct and the inconsistency between the criminal and the civil law, and related the public confidence principle back to the rationale, the consistency principle. And it was this interpretation, or that emphasis, that underlies Mr. Justice Garnham's judgment in this case. I take you to paragraph 141 of his judgment, which is at page 344. Paragraph 141, towards the bottom of 344. And he says it was suggested that the claim would be likely to offend public notions of fair distribution of resources, were the claimant to be compensated out of public funds and the public confidence is likely to be shaken by the obvious injustice of the claimant receiving damages for the killings, whilst the victims and their families would receive nothing. As noted above, the origin of the test, whether an outcome would be, as noted above, the origin of the test, whether an outcome would be offensive to public notions of the fair distribution, is the speech of Lord Hoffman and Gray. However, what he regarded as potentially offensive was that a claimant should be compensated for the consequences of his own criminal conduct, and the claimant here has been found not guilty of any criminal conduct.
Can a victim of something that is not an offence by reason of insanity make a claim to the Criminal Injuries Compensation Board?
Crimes of violence can be.
Yeah.
Yes.
But the fact that the perpetrator was acquitted by reason of insanity would not bar a claim to the Criminal
Injuries Compensation Board.
That's right.
In fact, that's dealt with, I think, by Mr. Justice Johnson in Trailer, is a good place to look at that. That was, if you like, the narrow approach taken to the public confidence test by Mr. Justice Garnham. In the Court of Appeal, Lord Justice Underhill gave the public confidence policy greater width or breadth, and he considers it from page 300 of the Court of Appeal's judgment, page 300 of your bundle. Yes, paragraph 102, the bottom of that page. I'm going to ask you to read that to yourselves, but before you do so, in this approach, Lord Justice Underhill works on the premise that the public confidence principle could be applicable to non-criminal conduct, and he equates the public confidence principle, at least to some extent, with the considered community values, which were considered by Justice Santow in the case of Hunter and Presland. And he says, Lord Justice Underhill says, we should be very slow to disregard considered community values. Perhaps I ask you to read paragraphs 102 and 103. And then at paragraph 104, he says, however, I've come to the conclusion that although the first reaction is entirely understandable, the values of our society are not reflected by debarring a claimant from seeking compensation of this kind of case. It is necessary, as Santow J.A. accepted, to go beyond instinctive recoil and to consider what justice truly requires in a situation which most humane and fair-minded people would recognize as far from straightforward. Taking that approach, although, of course, those who are killed or injured must always be treated as the primary victims, it is fair to recognize that the killer may also be a victim if they were suffering from serious mental illness and were let down by those who were responsible for their care. I rather suspect that some such view underlies the observations of the jury at the claimant's trial. But whether it does or not, I believe that the considered view of right-thinking people would be that someone who was indeed insane should not be debarred from compensation for the consequences of their doing an unlawful act, which is the term he's adopted, which they did not know was wrong, and for which they therefore had no moral culpability. And in my view, that reflects ordinary and comprehensible principles of fairness. I do not believe that it is rational, all that it would accord with community values, that the position should be different where the claimant's lack of knowledge or culpability was the result of insanity. In short, he aligns himself with the approach taken by Chief Justice Spiegelman in Presland. And then, having reached that conclusion in my submission with great care and caution, paying attention to the counter-arguments, he says, I think it's reinforced, paragraph 105, having reached that conclusion as a matter of principle, I think it's reinforced by the consideration that, as I believe, it reflects the tendency of the authorities and the implications of the reasoning in Clunis and that of Gray and Henderson. And a point I think worth making here is that it's more than 3 years ago that Mr. Justice Garnham gave his judgment in this case, in the same courtroom in Exeter Combined Court Centre as the jury heard the trial of Mr. Lewis-Ranwell. It's more than 3 years since Mr. Justice Garnham said, yes, this claim is not debarred by the illegality defence. And there's been some coverage, and it's been to the Court of Appeal, and the same thing has been said. And we're not aware of any public outcry or concern in relation to that. Whether, in my submission, you adopt the narrower view of the public confidence principle that Mr. Justice Garnham does, or the wider interpretation that Lord Justice Underhill does, the public confidence test favours not barring the claim and permitting it to continue. So in our submission, and there were more policies A considered in the written submissions, policies A in favour of the debarring the claim are not met. I'm going to just speed up a little bit. Policies B, the countervailing policies favouring continuance of the claim, are addressed in some detail in the written arguments from paragraph 107 onwards, which is at page 256 of the bundle. Just to pick a few of those, there is real public as well as private interest in courts adjudicating civil wrongs. It's a limited defence, only applied where to do so would cause that inconsistency. Neither underlying policy applies here, inconsistency or profiting from wrongdoing, and it would extend, as I've said many times, this defence beyond the reach of where it's ever gone before. There's a particular importance, I suggest, in protecting the private rights of mentally ill people cared for who come into contact with the mental health services provided by the state in the context of police custody. And yeah, I leave you to think, to look at the policies in the written, policies at B in the written case. Lastly, part C of the three considerations test in Patel, the proportionality test, or what is referred to, I think, in Henderson, Rondon, and more as the disproportionality test. If policies A and B are leading to the result that the claim should be debarred, then the court should go on to consider, well, would that application of this defence cause a disproportionately unjust result? We say it's not enlivened because on any view, A and B will point in the direction of allowing the claim to continue. But if the proportionality test is to be applied, I would ask you, please, to look and make your own minds up in relation to the degree of, or the extent of the negligence and the severity of the breaches of duty alleged here, which are set out very fully in paragraph 400, in the particulars of claim, which is at page 475 of your bundle. Set out in full so that you can see the flavour of that. And we absolutely stand by the fact that the claimant was a victim of a high order of negligent conduct on the part of the defendants, as described by the President at the Court of Appeal on our pleaded case. And that what followed was, in effect, an entirely foreseeable set of circumstances. There's a distinction drawn by my learned friend between whether it was foreseeable he would go and injure somebody, like the GBH he'd done yesterday, or whether he would go and kill somebody. Well, it's a distinction not relevant for these people. It was entirely foreseeable that he, effectively as a weapon, might cause injury or very serious injury or death to a person in this condition, because there had been explicit warnings about that. And this conduct caused the defendant to be very psychotic out in public, expose himself and then others to danger, caused him to kill the three people who died, the three men who died, and to himself suffer a significant injury in circumstances where he was so acutely unwell that he didn't know whether it was right or wrong. He was morally and legally irresponsible. And our submission is it would be a poor system of justice, which placed all of the losses at his door when others put him into that position, and in circumstances where it wouldn't bring the court into disrepute to allow the claim to be considered. It doesn't serve a public interest. It serves only the interests of the appellants. And our submission is that the law can and should coherently look at this part of the jigsaw. It can do, and it should do so. I'm going to draw my submissions to a close in order to allow Mr. Johnson to make his now, unless there's any questions arising from that.
Thank you very much, Ms. Plowden.
We have to swap seats. We'll just take a moment.
Yes, Mr. Johnson.
My lords, my ladies, my submissions turn to the matters raised in the appendix to the claimant's written case. That's at page 264 of the core bundle. In that appendix, we deal with three relatively distinct areas of the law: the coronial law, the forfeiture rule in the law of succession, and the suicide cases. That is, the application of this common law illegality defence to cases concerning suicide. And we suggest that each of those relatively distinct areas of law are relevant to the matter before this court. In my submissions, I'll go through each of those areas in turn, albeit I will take them slightly out of order, first dealing with the forfeiture rule. As set out at paragraph 2a in the appendix at page 264, at common law, a person who unlawfully killed another by murder or manslaughter forfeited any right to take benefit under that person's will or intestacy. I refer to this rule for two reasons. First, primarily, it's illustrative to consider how the forfeiture rule treats a person who killed whilst insane. The second, narrower reason is that, as with coronial law, which I'll come to, the term unlawful killing is used, and that term does not cover killing whilst insane. We have seen competing suggestions in the material reviewed about whether the forfeiture rule has its origins in the broader illegality rule. Regardless of that, the policy behind the forfeiture rule is clearly comparable to the policy behind the broader illegality rule.
But only private interests are involved. Is
Yes.
that fair?
Yes.
No public interest is involved.
I wouldn't agree with that.
Right.
The policies underlying the broader common law illegality rule are, as Ms. Plowden has said throughout her submissions, firstly, a criminal should not profit from their crime, but then secondly, the broader policy consistency. Just as McLachlan and Hall and Hebert, the law should not give with one hand what it takes with the other. And that arises very acutely in relation to the forfeiture rule.
It's not, occurs to me, this isn't the only aspect of consistency. We haven't, this point hasn't been raised yet, and I'm sorry it's being raised while you're on your feet rather than Miss Plowden. And if you want to leave it to her to reply, then. But it's occurred to me. The claimant brings his claim on the basis that he was insane.
Yes.
Is it open to the defendants to seek to establish that he wasn't?
Albeit, my lord,
No.
none of the defendants do so.
Sorry, I'm sorry?
None of the defendants do
No,
so.
but we're testing the principle here.
Yes.
So say the defendant's position is, well, he wasn't insane at all.
Yes.
He may have been of diminished responsibility. Is it open to them to defend the claim on a basis which challenges the decision of the jury? And if not, why not? Because they weren't party to those proceedings.
We have two potential responses to that. The first is the point that Ms. Plowden made, which is that this issue has not come before a court before. Mm-hmm. A claimant found not guilty by reason of insanity and a collateral challenge made by a defendant to that finding. So that issue has not come before a court. Our position is that a court should be slow to allow that collateral challenge. It should be that should be determined at the proper point in the proper case where it arises. But there are two possible outcomes. Either a collateral challenge will be precluded, potentially by a rule of common law, or the defendants will be allowed to make a collateral challenge to the jury's conclusion. They're the two possible outcomes. And we say that neither of those outcomes causes a problem for us.
If you're accepting that one possible outcome
yes.
is the court says, yes, the defendants weren't party to the criminal proceedings,
yes.
There's no abuse of process in seeking to establish, in defence of a claim being brought against them,
yes.
that in fact the claimant was not insane. Now, if that's a possible outcome, and of course they might then succeed in establishing that.
Yes.
Now, if that's right, you would have the criminal court obviously arriving at one outcome, the criminal court saying this man is not insane.
Yes. That's why our primary submission, if issue were to arise, would be that they should not be allowed to make the challenge. If we were wrong on that, and they were allowed to make the challenge, the analogy that we would draw would be to what happens at inquests. At an inquest, the conclusion isn't allowed to indicate a determination of a matter of civil liability. But as part of an inquest's findings, you see findings of fact that would be relevant, potentially, to a civil claim, findings about potentially the applicability of Article 2, about causation, and you see the ultimate conclusion that a coroner reaches. None of that is even admissible in subsequent civil proceedings. The matters can be relitigated, and we would draw the analogy there to the coronial law.
Your argument is that the preferable outcome
yes.
is for the defendants to be barred from challenging
it is.
From raising the question of sanity.
Yes.
And that's presumably by treating it as an abusive process.
I think it would have to be, but
and that's in order to avoid an inconsistency between
yes.
the civil and criminal courts.
Yes.
And obviously, the alternative is to say not that it's an abusive process for them to defend the claim, but for the claim to be brought.
Well, the alternative would be to allow them to make the challenge.
Yeah.
On the basis that they were not parties to the criminal case. They can adduce their evidence, and the judge in the civil trial can deal with it.
Yeah.
As with an inquest, though, we would say that the findings of the criminal court will give a very strong push to the parties to be able to anticipate what would very likely happen in the civil case.
Now, what if there hasn't been a criminal trial?
Yes.
Say in this case, just say for the sake of argument, the claimant had been shot dead by the police.
Yes.
After he had killed one or two of the victims.
Yes.
Obviously there'd be no criminal trial.
No.
His estate could presumably bring a claim.
Yes.
Now, so they bring a claim in civil proceedings. What do they have to prove? Do they have to establish that if the case had gone to trial, a jury would have been satisfied that he was insane? Or how is the issue of sanity going to be addressed?
My Lord, it would be open to the defendants to raise the issue of the illegality defence, and the defendants would have to prove that defence, and that would include this issue of insanity.
Well, the estate bring the claim. It's met with the illegality defence. Yes. The claimant's response to that is to say, that he was insane. So how is the issue of sanity going to be resolved?
It will have to be resolved through expert evidence. And I'm relying not here on case law, but on my own experience. It happens that we have to get expert evidence from psychiatrists who consider the medical records, consider witness evidence from people perhaps who knew the person in question, people who were there during the events, and then have to make a difficult assessment, but using that information about the person's state at that relevant time.
And the question would be whether the McNaughton test was satisfied.
In relation to the issue of illegality, it would.
Yeah.
Because we say that is the relevant test.
Yeah. Yes, thank you very much. I've taken you out of your order, and if I may say so, you've dealt very well with my questions.
Thank you, my Lord. My Lord, we were coming on to the case of Ree Horton.
So we're dealing with the forfeiture rule.
The forfeiture rule. Thank you, my lady. Ree Horton is it's one of 4 decisions that are cited in the appendix, claimant's written case, in relation to the forfeiture rule. It's a case from 1915, a decision of Mr. Justice Joyce in the High Court, and it's in the supplementary bundle at page 107. The facts of that case, in brief, it concerned a man, John Horton, who had killed his father and brother. He was tried and he was found guilty but insane. That gives you the historical context. This was 1915. It was before the 1954 amendments to the Trial of Lunatics Act. So the correct verdict was guilty but insane. The question for the court was whether the man, John Horton, the insane killer, was precluded by the forfeiture rule from recovering from the estates of his relatives. The answer, no. The forfeiture rule did not apply. He could recover. My lords, my ladies, I want to take you to the key passages of that judgment. But first, if I can take you to the argument that was rejected in that case. I do that because it has echoes of the arguments that were made by the defendants yesterday. Page 109, And at this page, the arguments that were made on behalf of the estate of the father are set out. Sorry, that's still in the supplementary bundle, of course. The second paragraph on that page, in spite of the statutory verdict, this cannot be said to have been an innocent killing. It is against public policy that a guilty person should benefit by his own act, and the court will not take away any of the restraints operating on the mind of man against the commission of such a crime or act. And then within that same paragraph, but towards the bottom, there's a number 7 around a third of the way up the page. And after the number 7, it says, "The sane human mind revolts at the very idea that a person of insane mind should be endowed with the fruits of his own crime." And in this case, the court is being asked to fructify a lunatic scheme. The special verdict in this case is not a verdict that the accused was guilty of the offence charged, but that he was guilty of the act charged as an offence. We say that there are parallels between the arguments that were deployed in this case re Horton and the arguments that are deployed by the defendants in the present case. In 1915, despite the verdict, the estate argued this was not an innocent killing. It's against public policy for the claimant to recover. It undermines the incentives against taking life. The verdict was not an acquittal. Those arguments were rejected in this case. We say they should be rejected in the present case. If we look at the reasoning, this is at page 112 of the supplementary bundle. In the penultimate paragraph, and it starts, if he had been found guilty of the act, if he'd been found guilty of the act, he would not have been found guilty of any offence. In other words,
sorry, you're reading from?
It is...
halfway down the penultimate paragraph.
Thank you, my lord.
If he'd been found guilty of the act, he would not found guilty of any offence. And then a reference to Felsted.
Thank you.
Having regard to the decision in Felsted and the King, the defendant, John Frederick Horton, if actually tried, would have been acquitted of any criminal offence, even if found guilty of the act of killing his father. Consequently, I can see no reason why he should not have taken any benefit under the will of his father. My lady Simler, if I can go back to the question that you asked when I brought up the topic, this is just an issue between private persons. We don't agree with that. If this had been a murder, a criminal offence, or offence of manslaughter even, there would have been one, the person committing the manslaughter would have effectively profited from that act in that they would have recovered the benefit from the estate of the person they killed, and two, there would be a significant inconsistency. The criminal law would be condemning and the civil law would be enabling that recovery. Here, though, the inheritance was allowed. We say that there are obvious similarities between re Horton and the present case. Both concern the question whether a claimant who is killed whilst insane should be precluded from his ordinary legal rights. And in re Horton, the conclusion was that he should not. The reasoning is straightforward, but it is in line with the key distinction that we have sought to make. Per Felsted and the King, the verdict, guilty but insane, was an acquittal, so the rule was not engaged. And that same straightforward reasoning is at the core of our submissions. If I can take that comparison further and make 4 points, I might have already made one of these. First, in Re Horton, they reached that conclusion before the amendment of the 1883 Act, guilty but insane to not guilty by reason of insanity. Second, the court might think that Re Horton was decided at a time when the societal view of mental illness was less developed than it is today. Third, I think I've made this point already, that Re Horton concerned recovery of inheritance, and that is much closer to the recovery of profit.
I'm sorry, I didn't hear the third.
I'm sorry, my lord.
I didn't hear the third.
Yes. In Re Horton, it concerned the recovery of inheritance, which is much closer to the recovery of a profit than the compensatory damages that are claimed by Mr. Lewis-Ranwell. Mr. Horton would be in a better position. We ask for Mr. Lewis-Ranwell to be put into the position he would have been in but for the defendant's negligence.
Yeah, that's the no profit point, really.
It is.
Yes.
The final point is that Re Horton concerned inheritance from the people who were killed. This has echoes of the scenario that was envisioned in Hunter and remarked upon by Lord Hoffman in Gray, where the insane patient kills his negligent doctor, and the court was unperturbed by it. I said now some time ago that I was going to turn to the law of succession, forfeiture, for two reasons. The first was to consider how it operates, because I say that's illustrative. The second was to do with how that area of the law treats the phrase unlawful killing. I'll deal with this briefly.
I'm afraid you're going to have to, because you've almost used up the respondent's time. Not you personally, of course, but your team.
I see that. My understanding, my lord, is that I have until past.
Well, you shouldn't really, because your team started 10 minutes early yesterday, so you ought to be finishing at 20 past, but I think we can be generous and let you go a few minutes beyond the 20 past.
I appreciate that. Thank you. Very quickly, the phrase unlawful killing appears in the Forfeiture Act 1982, and it would not cover killing whilst insane. I can move on then from that point. If I deal with coronial law equally quickly, unlawful killing is, of course, a conclusion that is open to a coroner. In a sentence, killing whilst insane is not unlawful for the purpose of coronial law. The authority for that is in the appendix, and it's R. O'Connor and Her Majesty's Coroner for the District of Avon. The final of the three topics that were dealt with in the appendix are the suicide cases. Cases concerning the application of the illegality defence to claims relating to suicide. There are two key points that the claimant makes in relation to these cases. The first key point is that it is the centrality when considering the illegality defence of criminality. And that's demonstrated in these cases by the difference in outcome before and after the decriminalisation of suicide. If I make this out before I then touch on the second, you have the case of Beresford and the Royal Insurance Company from 1938, a decision of the House of Lords before the decriminalisation of suicide. And in that case, before the decriminalisation of suicide, the illegality defence was held to bar a claim by someone who had taken their own life. You also have the cases of...
Bar the claim under the insurance policy.
Under the insurance policy, yes, my lady. You also have the cases of Kirkham, and Kirkham and the Chief Constable of Greater Manchester Police from 1990, and the case of Reeves and the Commissioner of Police for the Metropolis from 1999. Both had relatively similar fact patterns. They concerned people who were detained, making a claim against the police for failing to prevent their suicide. Both cases were after the Suicide Act of 1961, and in both cases the illegality defence did not apply. The point that I want to make in relation to these cases is that it was absolutely central to the reasoning that suicide was no longer a criminal offence. But not solely because of the lack of criminality, but also because of what that reflected about societal values. I won't take you to them, but I'd ask you to put into your notes. This can be seen at pages 1842, 1847, and 1848. The point's very clearly made. What I think has to be my final point, if I'm allowed the indulgence, is the very thing argument. This can be seen in the case of Reeves. Reeves, we have in the bundle the Court of Appeal decision at page 2124. Sorry, that's the larger bundle, page 2124. This went to the House of Lords, of course, but not on the illegality point. The very thing argument is seen in the judgment of...
Sorry, the which argument?
The very thing argument, and that's...
This is the very thing that is supposed to be prohibited.
And that can be seen in the judgment of Lord Justice Buxton at page 2140, the paragraph that begins by D. First, the defence fails on a logical ground similar to that which is fatal to the defence of Valenti, if it shocks the conscience of the ordinary citizen that a suicide could recover. Why is it the duty of the police, not merely as police officers, but in the private law of negligence, to take reasonable steps to prevent suicide? The case is, again, quite different from the usual application of ex turpe causa, where the plaintiff suffers injuries in the course of a criminal enterprise, such as an affray or burglary. Here, the alleged turpitudinous act is the very thing that the defendant had a duty to try to prevent, imposed by the law of negligence, which itself appeals to the public conscience, or at least to public notions of reasonableness. We say that this should come into Patel stage B. In our case, the defendants were under a duty to take reasonable steps to prevent Mr. Lewis-Ranwell from harming others. It's clearly a desirable duty. The rationale of the duty is to protect the public, to prevent harm from the mentally ill. And the duty would be deprived of force if it were not actionable. It's not a complete answer, but it is a further factor in our favour. I think I've probably gone on and tested the indulgence of the court. Thank you.
Thank you very much indeed, Mr. Johnson. Yes, Mr. Warnock.
My lord, my ladies. It was suggested that Apotex was an obvious case for consideration of the illegality defence because it was it involved knowingly breaching a patent for profit. In fact, as my lords and my ladies will recall, can you hear me?
Yes, I can.
As my lords and my ladies will recall, in fact, the Court of Appeal and Lord Twiston did not approach the case on that basis. And I'll not take you back to it now. It's paragraph 76 of the Court of Appeal's judgment at page 1869, where Lord Justice Etherton said that that was not an automatic bar to the illegality defence applying the issue of whether the defendants had knowledge or not, but was but one factor to be considered when looking at the public policies in play. But it was then suggested that there would be no inconsistency in allowing a claim by a person who was found not guilty by reason of insanity in a case where theoretically possible, although unlikely in practice, the insane person was released at trial on the grounds that they were better. But of course, in such a situation, there wouldn't be a claim for the detention in Broadmoor in the first place. So the question of inconsistency, by the very nature of it, wouldn't arise, quite apart from the fact...
Oh, God.
I hope it wasn't something I said.
Just carry on.
Quite apart from, of course, the public confidence principles which are in play too. It was then said the public policy underpinning the illegality defence does not include public protection. But on this, can I take you to what Lord Roger said by showing you what we've quoted from him in our written case? And it is at page 211 of the bundle, paragraph 43. And Lord Roger, considering the hospital order with restriction that was made in Gray, said this at paragraph 78 to 79. He said, "We must therefore proceed on the basis that Rafferty J. correctly considered that the orders which she made were necessary for the protection of the public from serious harm, having regard in particular to his violent attack. And by imposing the hospital order with a restriction, the judge was ensuring that because he had committed manslaughter, the claimant would not be free to move around in the community unless until authorised to do so by the Secretary of State. This meant, amongst other things, he was not free to work and earn while subject to the orders. In other words, his earning capacity was removed for as long as they were in force. In my view, it would be inconsistent with the policy underlying the making of the orders for a civil court now to award the claimant damages for loss of earnings relating to the period when he was subject to them." So Lord Rogers is there specifically addressing the public policy about the need for the protection of the public, which underlay the restriction and hospital order. Whilst we're in our case, my Lord Reid raised the question about might defendants contest the criminal outcome. And indeed, that is a point we've raised in our case at paragraph 54 on page 214, where we've said that allowing civil claims to turn on the distinction between NGRI and diminished responsibility is also liable to lead to conflicting decisions between the criminal and civil courts, because a defendant to a tort claim will not, of course, have been a party to the criminal proceedings and cannot therefore be bound by them as res judicata, or indeed by Hunter in a wider sense, because the defendant has no opportunity to be heard in those criminal proceedings. And indeed, we submit that the case of Gray and Barr shows that this is, in fact, a possible outcome, because my lords will recall that the defendants were allowed to run the illegality defence and succeeded on it. notwithstanding that the criminal proceedings had resulted in an acquittal. My lords and my ladies were then taken to the forfeiture insurance cases, and these, with respect to my learned friends, do raise different considerations. They involve the inheritance of property, usually according to a pre-written will by the person from whom it's inherited, or by the laws of intestacy as set out by statute. And indeed, in the Rehoughton case, one sees the reasoning was that statute hadn't precluded the claim under the intestacy provisions as one of the reasons for allowing it. But there are different policy considerations between forfeiture of property, which would otherwise have passed to the claimant under a will or by operation of statute, and the bringing of claims against third parties for compensation for the results of the killing, including that person's detention and loss of liberty and the matters which flow from it. And indeed, my lords who were and my lady, my lords who were in Henderson may recall that one of the claims that Ms. Henderson made was for a head of loss that she didn't recover under the Forfeiture Act because the forfeiture rule had applied to her. She had then applied under the Forfeiture Act for relief from the forfeiture rule, and her relief had been given to her for the extent of 50% of her share. And one sees that at page 1694 of the bundle. At paragraph 18 of the Court of Appeal's judgment, Lord Justice Etherton's judgment. That claim was barred by the public policy in the Henderson paragraph 18, which sets out that as a result of the order made in the Chancery Division, she was excluded for 50% of the interest she would otherwise have had under the will. Her claim for the 50% that she was denied was nonetheless held to be barred by this court for the reasons given by Lord Hamblin in relation to the claims as a whole. And no one suggested that the fact that she had been allowed 50% of her damages under the Forfeiture Act meant that she should be allowed 50% of her damages in tort against the Health Trust. And the reason for that is clearly that the public policies which arise in the tort claim are different. And indeed, Lord Hamblin, at page 1750, addressed the forfeiture. Paragraph 149 on page 1750 addressed this particular head of damage, and he said that the court had made the order it had, and it would be entirely inappropriate to subvert the operation of what he described as the specific and bespoke Forfeiture Act regime. So we submit it doesn't, in fact, address the public policies which arise in a claim of this nature against defendants who are being sued in tort for the effects of the killings and the results of the killings. In relation to the inquest cases, I'm afraid whether it will have reached my lords and my ladies yet, we've had another case uploaded onto the portal. It was I credit my learned junior, Mr. Harding, for finding it this morning, and it was supplied to my learned friends first thing this morning as well, with the references.
This Duggan?
It's Duggan.
Yes, we were sent that as an email earlier.
Thank you. It's helpful because the case sets out the history of the verdicts in the coroner's court. And at paragraph 37, this is from the divisional court. The case did go to the Court of Appeal where the outcome was upheld, but we're referring to the divisional court because it considers the history of the verdicts. And at paragraph 37,
and turn to page 13.
Page 13, yeah.
It's page 537 of the report. Sorry, I should say it's paragraph 38 I really want to go to. It said that the history of the verdict of unlawful killing is more fully explored in the judgment of this court in Wilkinson and Greater Manchester South District Coroner. The issue was whether the conclusion was confined to cases of murder, manslaughter and infanticide, or should be available in cases causing death by careless driving. The court rejected the contention that it should be available outside the three original categories. And I should have invited you to read paragraph 37, because paragraph 37 sets out the history. The history was that it was the coroner who was responsible for laying the indictment in the past. And it was because of that responsibility that the verdicts of unlawful killing in the way that they are emerged, so that one had unlawful killings for in the cases of murder, manslaughter, and then subsequently added infanticide. So that's the history of how the verdict of unlawful killing developed in the coroner's court. And then it was decided not to extend those verdicts post the change where it's the police and the CPS who proffer indictments rather than the coroner to that system. And at paragraph 72, in relation to whether the killing, what constitutes a lawful killing, the divisional court said, we conclude that the long-held understanding reflected in Sharman's case and by the editor of Jervis and Coroners, that the conclusion of lawful killing is one which would amount to the crime of murder, manslaughter, or infanticide, but for the presence of an additional factor which justifies it, is correct. So in other words, defences like self-defence. So we submitted the decision of the divisional court in the O'Connor case, which my learned friend...
I'm sorry, can you help me on 72? I'm not sure what point is being made.
Yes, I struggle to see its meaning.
The point I'm making is that if it's been suggested that a killing by reason of where there's a finding of not guilty by reason of insanity is a lawful killing, that's not the understanding of a lawful killing in the divisional court or in the coroner's courts. And indeed, in the case which my learned friend referred to, the O'Connor case, it wasn't suggested by the divisional court that a lawful killing verdict would be open to the jury. Instead, what was suggested was that there would be a narrative verdict.
So is your point that actually in coronial law, historically, unlawful killing has been limited to murder, manslaughter and infanticide,
yes,
and everything else is not an unlawful killing,
yes,
but it's not necessarily a lawful killing?
No.
But they just not extended it to other kinds.
They've not extended it, and the fact that it's not regarded as an unlawful killing in coronial law does not assist this court with the issue.
Because there are lots of kinds of killing which are not regarded as unlawful.
Yes.
Yeah.
Such as causing death by... I
think we see that in 70, in the last sentence in 70, it talks about the change in nomenclature from justifiable or excusable homicide, yes, to lawful killing.
Yes.
Yes. So a lawful killing is a justifiable or excusable homicide.
Yeah, that's they approve, paragraph 46, they approve a definition given in a textbook on coronial law.
But does that mean that in criminal law there is this third category? There's unlawful killing, there's lawful homicide, but there's also a number of ways of killing people which are criminal, but don't justify an unlawful killing verdict.
Well, certainly in the coronial law, as it's developed, you couldn't have an unlawful killing verdict where there's not guilty by reason of insanity according to the way the law has developed. But what we're submitting is that does not mean it's not an unlawful killing. That jurisdiction has developed that way for a particular reason.
Yeah.
It doesn't mean it's a lawful killing. The suicide cases raise very different considerations. First of all, they don't raise the public protection considerations. They don't raise the consistency considerations. And there is a distinction we submit between killing oneself and killing other people, and the prohibition on taking the life of others. My Lords and my ladies, I think I've used at least my time for the reply, and perhaps some of my learned friends. But
Very well, thank you very much, Mr. Warnock. Yes, Miss Ayling.
My lords, my ladies, I've got two very short points of fact which I wish to address, and then 5 equally short points in reply. So the first 2 points of fact, just to tie them down, I believe, thank you, that Lady Rose asked Ms. Plowden this morning what the jury knew, whether they knew that the 3741 disposal would follow in either case. It's not, I would suggest, clear. They certainly did know at some stage, and this is page 680 in your bundles. Between E and F, addressing the jury, she says the result, as you've heard, is the same. He will be cared for in hospital with a restriction order, which means that he won't be allowed into the community. So they did know, but it's not clear
That's
whether...
only after
Yes.
the verdict.
So it's
I think
not...
my lady's question
it
was
was.
whether they knew going into the
It isn't clear, one way or the other, is my short submission on that.
It'd be unusual to tell the jury what the disposals are likely to be,
Yes.
in my experience.
Yes. But I think the answer isn't clear one way or the other, but I'll leave it at that. The other point I just wish to make about what happened at the criminal trial was that the only question that was left to the jury was what he knew, whether he knew that the matter was wrong legally or morally, and that is clear from page 669. That was the only question that was left to them. There was a clip of agreed facts, and we don't know quite what was in that. But the only question was whether the jury was satisfied that he did not know that what he was doing was against the law.
So that it was limited to the second limb of McNaughton?
Yes.
Yeah.
So turning then to the short points I will make. My Lord Reid asked me yesterday whether an answer was to start with general policy considerations, and my answer to that now is that it is, and that flows, I suggest, from Henderson itself. If you turn to Lord Hamblin at para 113, which is page 1744, he addresses, having considered the question of ratio and whether Gray remained good law, he turns then finally to consider whether the application of Patel leads to a different outcome than the outcome in Gray. And at para 116, at page 1745, he explains exactly how, under the trio, relevant policy considerations are to be weighed. It appears this must involve a balancing between considerations arising at the first and second stages. Stage A is directed at policy reasons which support denial, and stage B is directed at policy reasons which support denial of the illegality defence. The first stage is denial of the claim. At para 119, on the same page, he explains that stage A is not confined to the specific purpose of the prohibitions. General policy considerations that impact on the consistency of the law and integrity of the legal system fall to be taken into account. And then at para 125, on page 1747, he turns to apply stage A, or to address stage A, and he says in terms at para 125, as explained above, this stage involves identification of policy reasons which support denial of the claim, considering first general policy considerations rather than the purpose of the consideration. The consistency principle is engaged. And so that's what he does. He looks at the policy reasons first and then turns to consider the purpose of the transgression. So we say that is policy being looked at first at both stages A and B of Patel before you come on to consider the purpose of the prohibition transgressed. Before you come on to consider the purpose of the prohibition transgressed. So that is what he is doing in our submission at paras 125 and onwards. Just turning then to a specific point which Lady Rose asked me yesterday, and I gave an answer, but I just want to pin it down. You asked me if self-defence made the unlawful act a lawful act, and I appreciate that we don't want to get tangled any further in that particular taxonomy. I said that it did make a killing a lawful act. The important thing is that it results in a complete acquittal. But if you look at the Attorney General's reference number 3, which we looked at yesterday, at page 1154, the example of an individual surrounded by a group of aggressive and armed youths, the judgment says in terms, it would be unjust if he were prevented from inviting the jury to consider that his violence might have been lawful. And that is the conversion to a lawful act in my submission. Just turning then to the question of the how far Henderson addressed the question of what would happen in an insanity case. The submissions in Henderson begin at page 1717. The submissions for the respondent. You will see some of the same protagonists there. Mr. Moon and myself and Mr. Gookamp. And if you look over the page at 1718, you will see at Roman 4, which is between E and F, that we addressed the question of the insanity verdict and said that it didn't arise on the facts of this case. It does not need to be addressed by this court, and the judgments in Henderson do not address it in terms. And we say it is too much to draw from the judgments in Henderson an implication that insanity is covered by the reasoning. Penultimate point, Mr. Warnock addressed you on the fact that if there'd been an absolute discharge, there would effectively be no claim because this claimant would not have been detained. I think then it's important, I took you yesterday to the schedule of loss, and I won't do that again, but a large part of those losses flow directly from his detention, as indeed they did in Henderson itself. And let me give you the reference to the losses claimed in Henderson. That is at page 1749. And you will see that they, in large part, just let me check that. Yeah, the final paragraphs on that page address in turn the damages for loss of liberty, loss of immunity barred by the narrow rule, the other heads of loss are barred by the wider rule, and in fact the losses claimed are itemised at page 1726. I won't take you there. I will make this point about those losses, and I must stop. Our written case addressed you on the fact that it was possible for the illegality defence to operate in a modulated way so as to allow some heads of loss and to disallow others. That is not a conclusion I'm urging you to reach, but it is a possibility if that were considered appropriate. So that's in our written case at page 169, para 33, and that is part of the illegality defence's ability to operate sensitively according to public policy, public consistency and public confidence.
Yes, I mean, that must make sense given little c of the trio test. Is it disproportionate to bar the claim? It may be disproportionate to bar it in part.
Yeah, exactly, my lady.
Which paragraph was that?
Page 169, para 33 of our written case. And then very finally, Ms Plowden says that it is common to see in a claim for personal injury a claim for restriction of liberty if a Section 2 or 3 order under the Mental Health Act has been made. I'm not sure that's quite right, but I think my submission is that in this case it doesn't matter because, as Mr Moon said to you yesterday, there was an act which led to the court making the order under sections 37 and 41. And if you look at the facts of Gray, that's in fact exactly what happened. So he had a good claim against the railway company until the killing. And once the killing had happened, his claim was barred by the illegality defence because of the operation of the criminal court imposing a sentence and the restrictions on his liberty thereafter. Those are my points in reply.
Thank you very much, Ms Ayling.
Yeah.
Well, as my ladies, I may have to exercise a bit of triage on my fly. I'm just going to take the most important ones. And it follows really from something that my friend Ms Ayling said. The problem with the focus on Lord Sumption's approach, which is generated really by the respondent submissions, is that the law was hidebound by earlier cases up to the time of Patel. And Patel relieves the court of the burden of looking at the old cases in great detail and trying to work out which ones apply, but gives the court a different approach in a case which is like this, in fact, to use old-fashioned language, sui generis. The insanity case, the case of someone who's been found not guilty by reason of insanity, is simply not one that has been considered head-on in any of the earlier cases. And that is precisely where Patel comes in. And of course, it is right to proceed carefully on a case-by-case basis. But provided one does that and applies the Patel test, then one does not need to go, first of all, to decide what the threshold is. And indeed, in our case, which appears, that's the first Appellants case between pages 133 and 154, we do not start with the question of, is there a threshold? Our submission has been, from the outset, go to Patel. And that is precisely what we submit should be done here. And there are two critical public policy issues. The first is the consistency principle, and the second is the public confidence principle. They are, however, connected. And Lord Hamblin made this point at paragraph 58.4, that the consistency principle and the public confidence principle are related because it would undermine public confidence if there was inconsistency in the sense that we have submitted, namely inconsistency between the disposal made by the criminal court and the claim for damages. Just to follow that point up, if I may, the respondent submitted at one point that the disposal under sections 37 and 41 was equivalent to what was described as a section 2 or section 3 order. There is no such thing as a section 2 or a section 3 order because, and I submitted to this effect yesterday, the court makes no order under sections 2 or section 3 of the Mental Health Act. It is a recommendation made, an application made based upon the recommendation, the written recommendation of 2 registered medical practitioners. And the court simply doesn't get involved. The same is true of what my learned friend described as Dole's cases, that is to say, deprivation of liberty cases. For the most part, deprivation of liberty, I'm not going to call them orders, but deprivation of liberty provisions are dealt with on the basis of recommendations which are then applied by the local authority. There is no court order made in relation to most administrative Dole's provisions. And there are circumstances in which the Court of Protection may make a Dole's order, but in those circumstances, there might well, if it ever arose, be a question about consistency. But the vast majority of cases do not involve a court order. My lords, my ladies, I was going to make a very short point on the facts, and I hope I can do it in 1 minute. My learned friend suggested right at the outset of her submissions that one could aggregate the defendant's knowledge. The way it was put was the defendants collectively had knowledge of the various events that had occurred. That is not the way the law of tort works. Each defendant's knowledge is judged separately. Each defendant will be judged separately in relation to whether there was a breach of duty, and one does not aggregate the knowledge of one defendant with another. And the particular example that was given was that the defendants all had access to the mental health records. That is, with respect, factually not correct. So far as G4S is concerned, there is no allegation that G4S had access to the mental health records, and I would ask the court to look at paragraphs 17, 63, and 93 of the particulars of claim at pages 479, 490, and 496. In fact, G4S did not have access to the mental health records, and that is pleaded at page 546 in the defence. And so that suggestion, the basis of the suggestion that you could aggregate knowledge, led to the ultimate contention made on behalf of the respondent that this was a high order of negligence. We don't accept that. We don't accept that, judged individually, each of these defendants each of these appellants was guilty of a high order of negligence. So, my lords, my ladies, unless there's anything else, I've taken that probably too fast.
No, we're very grateful to you, Mr. Moon, for being succinct. Thank you very much, Mr. Moon. No questions, I think. Thank you. Well, we're very grateful to all counsel for the assistance that we've been given. This is obviously a difficult and important issue. We'll take time now to consider it and let you have our judgment probably next term.